Jimmy.
Steve.
Often is the case, we get a call from somebody, not always a woman, but more often than not a woman who says, my boyfriend, husband, roommate, significant other, ex-husband has hit me, slapped me, pushed me. What can be done about this?
Well, a lot of times in situations like that where there has been some sort of violence, physical violence, a temporary protective order, a TPO, can be filed.
Okay. Now, is this written down in the law in Georgia?
Yes.
Okay. And as I recall, to seek a temporary protective order, you must first fall within a class or a subset of specific people. Is that right?
Yes.
Now, that would be husband, wife,
Yep.
or former spouses,
Yep.
or children and parents,
Yep.
or people who fathered or mothered the same child,
Yep.
right? Or former roommates even, right?
Yeah, and
Okay.
there's a pretty wide category of what goes into it to be classified as family.
Right. Now, the first step is to determine if the person falls in that class.
Yes.
So that's what a judge, like the excellent Judge Alex Manning over in Fulton County might do. They determine if the classification fits. And then the next thing they have to determine is what? Do you remember?
Well, it's whether that violence occurred.
Well, okay. And the violence can be one of two flavors, right? I'll help you out. The first flavor is any felony. So if one person who has an intimate relationship with the other commits any felony, a TPO could be granted, right?
Yes.
And what's the other class? Do you remember? No, it's okay if you don't. It's a specific enumerated subset of misdemeanors like assault, battery, stalking, right? So either or, right?
Yep.
So you could have hit somebody, like if I hit you like that, that's a battery. If I threaten to hit you like that, it's an assault, right? But I recently had a case where my client was accused of accessing the other party's personal information, like medical information, which is in fact a felony. And the judge found that there was absolutely no credible evidence of assault or battery or threats, even though they attempted to introduce text messages that said that. But at the end of it, the judge said, yeah, but I still see that very likely a felony of invasion of privacy has occurred, which is, again, a felony. So it could qualify either, from a violent act, which is what we most often think of, but it could also be something like an invasion of privacy. Right?
Well, now, in a situation like that, it also brings in a different thought as to where that criminal case actually is. And
could be. Yeah.
And whether it's merely an accusation and there has not actually been a conviction, and whether that can still go in as far as granting a TPO.
Well, that's interesting because now what you raise is what's the quantum or the amount of proof that you need at a TPO? Is it the same as a criminal case, which is beyond a reasonable doubt, the law's highest standard, or is it a lower standard at a TPO?
Well, generally it's going to be whatever the judge thinks that
yes, but,
that it is.
But technically it's a preponderance of the evidence, which is basically defined as 50% plus a slight bit more. So if the evidence could go either way and it's slightly more compelling that the act happened, even if it's just a tiny bit, that meets what's called the preponderance standard, right?
Yep.
Okay. So to summarize, a temporary protective order can be granted if there is an intimate relationship between people like former spouses or current spouses, and one of them, the aggressor, has either committed a felony or any one of about 6 or 7 specific misdemeanors like assault, battery, or stalking, right? And there has to be evidence that without the TPO, this could likely continue.
Absolutely.
Right. All right. Catch us on our next video where we talk more about the temporary protective order process.